In a landmark unanimous judgment, the Supreme Court on Thursday, February 15, struck down as unconstitutional and manifestly arbitrary the electoral bond scheme, which provides blanket anonymity to political donors, as well as critical legal amendments allowing rich corporations to make unlimited political donations. A five-judge bench headed by Chief Justice of India D.Y. Chandrachud and Justice Sanjeev Khanna, R Gavai, J.B. Pardiwala and Manoj Misra held that the scheme and preceding amendments made to the Representation of the People Act, the Companies Act and the Income Tax Act violated the voters' right to information about political funding under Article 19(1)(a) of the Constitution. The lead opinion, authored by Chief Justice Chandrachud, said that the absolute non-disclosure of the source of political funding through electoral bonds promoted corruption and a culture of quid pro quo with the ruling party to introduce a policy change or for bagging a license. The scheme and the amendments authorized unrestrained influence of corporates in the electoral process, it said. Would we remain a democracy if the elected do not heed the hue and cry of the needy? We ask ourselves whether the elected would truly be responsive to the electorate if companies which bring with them huge finances and engage in quid pro quo arrangements with parties are permitted to contribute unlimited amounts, Chief Justice Chandrachud noted. He said that the scheme and the amendments promoted economic inequality by giving corporations with financial power an unsurpassable advantage over ordinary citizens in the electoral process and political engagement. This is violative of the principle of free and fair elections and political equality captured in a value of one person, one vote, Chief Justice Chandrachud said. What is the electoral bond scheme? These were interest-free bearer instruments which citizens or corporations could anonymously purchase from the State Bank of India and then donate to political parties to fund election expenses. They were introduced in the 2017 Union Budget by then Finance Minister Arun Jaitley to cleanse the system of political funding in the country and bring about transparency in electoral funding in India. Notably, the SBI has sole access to the details of those who purchased electoral bonds. According to the scheme, the proceeds from any bonds which are not encashed within 15 days of being issued are to be deposited in the Prime Minister Relief Fund. Petitions were filed by the Communist Party of India, Marxist, Congress leader Jaya Thakur and NGOs Common Cause and Association for Democratic Reforms ADR. They argued that the anonymity associated with electoral bonds undermines transparency in political funding and encroaches upon voters' right to information. They further contended that the scheme facilitates contributions through shell companies, raising concerns about accountability and integrity in electoral finance. In defense of the scheme, the Union government had asserted its role in promoting the use of legitimate funds in political financing, ensuring transactions occur through a regulated bank. The court dismissed the Union government's argument that the anonymity of political donors afforded by electoral bonds incentivized financial contributions through banking channels. The court agreed that the fundamental right to privacy covers a person's political affiliation. However, it said there should be a balance between informational privacy and the voter's right to information. Chief Justice Chandrachud drew a clear distinction between donations by corporates for favors and contributions by individuals as a mark of their political beliefs. Not all contributions are made to alter public policy. Contributions are also made by people to political parties which are not substantially represented purely with the intent of extending support. Contributions made for quid pro quo are not an expression of support, the Chief Justice distinguished. The court rubbished the government's claim that the scheme was meant to curb the injection of black money into the electoral process. It ruled that curbing of black money was not a reasonable restriction to the exercise of the voter's fundamental right to information about political funding enshrined in Article 19(1)(a). The court held that the RTI can only be restricted based on Article 19(2), which speaks of the reasonable restrictions to freedom of speech and expression. It does not include curbing black money as a restriction. Even assuming curbing black money is a legitimate purpose, it is not proportional to the restrictions posed by this scheme. Further, it said this scheme is not the only means to curb black money in electoral financing. Other options are less restrictive and fulfill this purpose. The Chief Justice asked the Union government how the absolute non-disclosure of the sources of political funding introduced in the electoral bond scheme could rationally help curb black money. Clause 7.4 of the scheme completely exempts information on the purchasers of electoral bonds. This information is never disclosed to the voters. The purpose of securing information about political funding cannot be fulfilled by absolute non-disclosure, the Chief Justice pointed out. The judgment referred to the way that amendments had been introduced in Section 29C of the Representation of People Act, Section 13A of the Income Tax Act, and Section 182 of the Companies Act via the Finance Act 2017. Introduced as a money bill to pave the way for blanket anonymity in financial contributions through the electoral bonds route notified in January 2018. Prior to the amendments, these provisions had maintained the needed balance between donors' privacy and voters' right to know, the court said. Prior to the amendments, these provisions had maintained the needed balance between donors' privacy and voters' right to know, the court said. Section 29C requires parties to prepare a report detailing the donations received by them in financial year. They are required to declare all contributions higher than Rs 20,000 and specify whether they were received from individuals or from companies. The Finance Act 2017 amended the Representation of the People's Act to include an exception to Section 29C. It said that the requirement to declare all donations in excess of Rs 20,000 would not apply to donations received through electoral bonds. The court struck down the amendment and observed that the original requirement to disclose contributions of more than Rs 20,000 did an effective job of balancing voters' right to information with the right to privacy of donors, as donations below this threshold were far less likely to influence political decisions. Section 13A(b) of the Act says that a political party shall not include voluntary contributions as part of its total income, but it is required to maintain a record of all contributions received that are above Rs 20,000. This record must include the name and address of the person who has made the donation. The Act amended this section to include the words other than contribution by way of electoral bond. Also, a new section 13A(d) was added, which required that all donations exceeding Rs 2,000 must be given through certain methods, which included electoral bonds. The court held that the exempting political parties from maintaining a record of donations received through electoral bonds would violate the right to information of voters under Article 19(1)(a) of the Constitution. The court struck down both the amendment to Section 13A(b) and the new Section 13A(d). Changes were made to Section 182, which details the prohibitions and restrictions a company must abide by when giving to parties. Prior to the amendment, Section 182(1) capped the amount of money a company could donate in a single financial year, limiting it to 7.5% of the company's average net profits during the previous 3 financial years. Section 182(3) required a company to disclose any amount contributed to any political party along with the particulars of the amount donated and the name of the receiving party. This section was amended to remove the cap on the amount of money a company could donate to a political party. Also, only the total amount contributed had to be disclosed, and the company would no longer be required to declare which political party it had sent a donation to, nor the specific amount. The court struck down this amendment. Chief Justice of India Chandrachud observed that permitting unlimited corporate contributions authorizes unrestrained influence of companies in the electoral process. The court held that this violated the right to free and fair elections and restored the original provision which is meant to curb corruption in electoral financing. The pre-amendment provision had also banned government companies from making contributions to prevent them from entering the political fray. It had moreover classified loss-making companies and profit-making ones. The underlying principles was that it was more plausible that loss-making companies would contribute to political parties with a quid pro quo and not with income tax benefits in mind. The amendment to Section 182 does not recognize that the harm of political contributions by loss-making companies for quid pro quo is higher. The amendment is arbitrary for not making a distinction, Chief Justice Chandrachud held. The Supreme Court said the influence of money over electoral politics is not limited to poll outcomes, but spills over to government decisions as well. The legal regime in India does not distinguish between campaign funding and electoral funding. The money which is donated to political parties is not used by the political party only for the purposes of electoral campaigns. Party donations are also used, for instance, to build offices for the party and pay party workers, observed Chief Justice of India. At a primary level, political contributions give a seat at the table to the contributor or enhanced access to legislators. The access also translates into influence over policy making. An economically affluent person has a higher ability to make financial contributions to political parties, and there is a legitimate possibility that financial contribution to a political party would lead to quid pro quo arrangements because of the close nexus between money and politics, the court said. The Chief Justice said the influence of money over politics has made it necessary for voters to access information about political funding, which will enable them to access if there is a correlation between policy making and financial contributions. At the time it was being conceived, the electoral bond scheme faced a criticism from two key institutions, the Reserve Bank of India (RBI) and the Election Commission of India (ECI). While both had differing concerns, prevention of money laundering was a common ground. The RBI had three main arguments. Such an amendment would enable multiple non-sovereign entities to issue bearer instruments. The RBI had argued that this proposal to allow any other bank to issue electoral bonds militated against RBI's sole authority for issuing bearer instruments, which has the potential of becoming currency. RBI was of the opinion that if such electoral bonds are issued in sizable quantities, they can undermine the faith in bank notes issued by the central bank. The RBI also noted that while the identity of the person or entity purchasing the bearer bond will be known because of the know your customer requirement, the identities of the intervening persons entities will not be known. This would impact the principles of the Prevention of Money Laundering Act 2002, it stated. The RBI was the opinion that the intention of introducing electoral bonds, that the electoral contributions be paid out of tax-paid money, can be accomplished by check, demand draft and electronic and digital payments. There is no special need for introducing a new bearer bond in the form of electoral bonds, it stated. RBI stated that permitting a commercial bank to issue bonds would have an adverse impact on public perception about the scheme, as also the credibility of India's financial system in general and the central bank in particular. The RBI reiterated the possibility of shell companies misusing bearer bonds for money laundering transactions. It also warned that the issuance of electoral bonds in the scrip form could also expose it to the risk of forgery and cross-border counterfeiting. The Election Commission's main objection was that electoral bonds would have a serious impact on transparency of political finance funding of political parties. In May 2017, the Election Commission of India wrote to the Ministry of Law and Justice about the amendments to the Income Tax Act, the Representation of the People Act and Companies Act introduced by the Finance Act 2017. In it, the Election Commission of India stated that the amendment which has been made, that any donation received by a political party through electoral bond is out of the ambit of reporting under the contribution report as prescribed in Representation of the People Act 1951, is a retrograde step as far as transparency of donations is concerned, and this proviso needs to be withdrawn. Further, referring to the deletion of the provision in the Companies Act requiring companies to disclose particulars of the amount contributed to specific political parties, the Election Commission of India had recommended that companies contributing to political parties must declare party-wise contributions in the profit and loss account to maintain transparency in the financial funding of political parties. The Election Commission of India had also recommended that the earlier provision prescribing a cap on corporate funding be reintroduced because unlimited corporate funding would increase the use of black money for political funding through shell companies. The court issued the following directions. A. The issuing bank shall herewith stop the issuance of electoral bonds. B. The State Bank of India shall submit the details of electoral bonds purchased since the interim order of the court dated April 12, 2019 till date to the Election Commission of India. The details shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased. C. State Bank of India shall submit the details of the political parties which have received contributions through electoral bonds since the interim order dated April 12, 2019 till date to the Election Commission of India. SBI must disclose details of each electoral bonds encashed by the political parties, which shall include the date of encashment and the denominations of electoral bond. D. SBI shall submit the above information to the Election Commission of India within 3 weeks from today, that is by March 6. E. Election Commission of India shall publish the information received from the SBI on its website by March 13, 2024. F. Electoral bonds which are within the validity period of 15 days but which have not been encashed by the political parties yet shall be returned by the political party to the purchaser. The issuing bank shall then refund the amount to the purchaser's account. According to data by the Association for Democratic Reforms (ADR), which was the chief petitioner in the case in the court, the collective amount of funds generated through the sale of electoral bonds between March 2018 and January 2024 is 16,518.11 crore. An analysis of the electoral bond scheme shows that the ruling BJP garnered the lion's share of nearly 55% of the funds till March 2023, while its closest rival Congress got a mere 9.3%. The highest sale of bonds was during the last Lok Sabha polls in 2019 from April 1 to 20 when bonds worth 2,256.37 crore were sold. The BJP till March 2023 received 6,566.11 crore through electoral bonds, while the Congress got 1,123.29 crore. The ruling party got a maximum of 2,555 crore in 2019-2022 as compared to the Congress 317.86 crore, according to annual audit reports made public by the Election Commission. In his separate opinion, Justice Sanjeev Khanna analyzed the audit reports of political parties from 2017-2018 to 2022-2023. His data showed that the BJP got 210 crore in 2017-2018 at the start of the scheme and racked in 1,294.14 crore by 2022-2023. The Indian National Congress is far below at 171.02 crore, while the All India Trinamool Congress AITC received 325 crore and the DMK 185 crore in 2022-2023. It is clear that majority of contributions through bonds went to ruling political parties in the center and the states, Justice Khanna observed. The judge also gave details of the denomination-wise sale of electoral bonds from March 2018 to July 2023. Justice Khanna said over 50% of the bonds sold were in the 1 crore denomination during this period. Senior Advocate Kapil Sibal, Advocate Prashant Bhushan, Advocate Shadan Farsad, Advocate Nizam Pasha, Senior Advocate Vijay Hansariya, Senior Advocate Sanjay Hegde appeared for the petitioners. Attorney General for India R Venkatramani, Solicitor General of India Tushar Mehta appeared for the Union Government. If you enjoyed this video, then please like and share this video, do subscribe to the channel and don't forget to click the bell icon.